In the Australian legal profession, barrister Stephen Keim and lawyer Terry O'Gorman are known to all. Indeed, they're arguably well known beyond that as well. And like Bob Moles, who you'll hear from as well. All three have Wikipedia pages, which I don't think is very meaningful to the young people today. It might be if they were on social media, they would have a lot of followers maybe. They have decades of experience as social justice warriors in Australia and continue that work, and in Terry's case, even into his so-called retirement. Stephen and Terry are both members of the Griffith University Innocence Project Advisory Board, which we're very proud of, and Terry O'Gorman couldn't be with us today, unfortunately, but Stephen will present their co-authored paper that discusses some of the central questions around setting up a CCRC organisation in Australia. Thank you, Stephen.
Thanks, Robin. Hello, everybody. I'd also like to acknowledge the traditional owners. It's nice to be here so soon after Invasion Day. It means that I, a committed Northsider, has crossed the river on 2 occasions in 4 days. As Robin told you, I am sharing this session with an absent friend, the very distinguished Terry O'Gorman AM. Terry is not able to join us today, as Robin said. I suspect that lack of brownie points, a chronic problem experienced by Terry, may be a contributing cause to his absence. However, Terry has prepared an excellent paper which will be available in due course, if not already. I have incorporated parts of the paper into this oral presentation, and Terry has given his approval to my speaking notes, so that's a good start. But I think to do justice to Terry's paper, you need to read that in whole to give it full value. I start this discussion on the basis that you are convinced that enough miscarriages of justice slip through the safeguards of the justice system to cause you considerable concern. I also assume that you are convinced that the concept of a Criminal Justice Review Commission is part of the solution to right those wrongs. I'll even assume, and this is probably a fair assumption having watched the last two remote presentations, I'll even assume that you have a fair idea of the sorts of independence, integrity, competence, structure, resources and authority that must be bestowed upon a commission to give it the maximum chance of being effective. The reason why I'm showing such restraint is that you have a whole program of distinguished speakers that will address you on those very issues. Having said that, Terry's paper does canvass many of the arguments for the existence of a CCRC. The questions that I will seek to discuss are why a Commonwealth body is to be preferred to individual state and territory bodies, question number one, and what are the legal complexities which must be addressed for a Commonwealth body to be able effectively to address, investigate and deal with miscarriages of justice wherever they occur in jurisdictions across the Australian continent. That's question number two. So the pros and cons of a Commonwealth body. In many ways, the arguments for a national CCRC, as opposed to individual state and territory CCRCs, are the same as in other areas of government and regulatory activity. If only I had my Government of Australia textbook from 1972 or 1973, I'd be able to articulate those arguments almost by rote. National bodies allow for uniformity across the whole nation so that any person or entity being regulated does not have to wrestle with different rules when they travel interstate. Road rules and signage and corporations laws are examples of this. National bodies tend to be more economical because it is cheaper to have one HR system, one IT consultant, and one set of letterhead. State and territory initiatives allow for one jurisdiction to pioneer an area, allowing others to follow. This has happened with the second appeals legislation and, albeit very slowly, with human rights charters. Also, within a particular activity, a multiple of jurisdictions allows diversity and experimentation as between different states and territories. Different human rights legislation has allowed particular states and territories to be more or less brave when seeking, for example, to legislate economic and social rights, as opposed to civil and political rights. It is fair to say that since I lost my 1970s Government of Australia textbook, the increasing economic integration and mobility across jurisdictions in Australia has led in many areas of government activity to greater pressure for national as opposed to state and territory systems. Corporations legislation is a strong example of this type of development. You probably remember all those cases involving the New South Wales CAC, which you don't see anymore. In his paper, Terry looks at the expressed attitudes of governments and politicians to the idea of introducing a CCRC in their jurisdiction. This analysis contains some expressions of reasons why a particular approach may be preferred. Most of the references come from Tasmania. Terry notes that in that Tasmanian context, some advocates have argued that the state should not wait for a national body, but should create something locally. Terry quotes former Premier Lara Giddings, arguing that Tasmania could minimise costs by having a CCRC sit under another related body, such as an Integrity Commission. Still, in Tasmania, some advocates argue that a shared national body is more efficient, while others point to the delay associated with a national commission being established, and that a lean, low-cost body should be established to avoid delay. Terry also notes that Professor David Hamer, who is a friend of this area and many of us, Professor Hamer argues in his December 2025 paper that for economies of scale, Australia should have a national CCRC. Inefficiencies appear inevitable if separate bodies were established for all the states and territories, especially in the cases of the Northern Territory, the ACT and Tasmania, each of which jurisdictions has a population well under 1 million people. Professor Hamer does point out, however, that establishing a national commission is not straightforward because the criminal law is a matter for the states and territories in Australia, and he contrasts this with Canada, where, as Professor Roach just explained to us, the criminal law is the responsibility of the national government, not the provinces. Each of the arguments about whether a CCRC should be one national body or a number of separate bodies established in individual states and territories and at a Commonwealth level has some validity. Nonetheless, I think the consensus is that if a national body can be achieved in our lifetimes, it will be a much better option than a collection of under-resourced and higgledy-piggledy state and territory bodies. Indeed, Terry finishes his paper with a call to action and something of a roadmap for a strong and well-coordinated campaign to achieve a national CCRC. I note that this afternoon's activities are also intended to chart a way forward with just such a campaign. So they're my thoughts on, or our thoughts on the first question. Let us now turn to what we've called legal complexities of a national CCRC. The powers of a generic CCRC include the power to receive applications from members of the public for their convictions to be investigated, and the discretionary power to accept such applications. In accepting an investigation, the CCRC makes a decision to expend public resources upon the investigation. However, the advantages of a CCRC over mere second and subsequent appeals legislation involve not only public resources, but the authority or power to have access to the information or documents required for an investigation. CCRC investigators need to have the authority to access information in court files, police files, and other government files. A properly empowered CCRC also needs to be able to access information in private hands, so that right of entry, power to seize documents and objects, and the power to require answers to questions need to be bestowed upon a national CCRC. The CCRC also requires the authority to bring an appeal to the relevant court to overturn the conviction. The court needs jurisdiction to hear and decide the appeal and to make appropriate orders, including to grant the appeal and overturn the conviction. The need for all of this authority brings complications in the case of a national CCRC intended to operate in state jurisdictions. The authority to demand information from state institutions in respect of state court decisions made under state laws does not fall under any obvious Commonwealth parliamentary power under Section 51. Neither is the authority to bestow new jurisdiction on state courts concerning existing state court decisions. Even the source of authority to appropriate and spend Commonwealth public resources on correcting injustices involved in state justice decisions is less than obvious. Professor Hamer notes that the practical problem that CCRC investigators will be working in the context of laws and procedures that vary from jurisdiction to jurisdiction is not an overwhelming one. He notes that Australian law is quite unified. There is only one common law, and federal laws are the same in all jurisdictions. Uniform evidence laws apply in a number of states and at a federal level. A lot of substantive criminal laws are deliberately as similar as can be achieved practically across the different jurisdictions. Cross-vesting laws permit courts to apply laws from different jurisdictions where the factual situation involves causes of action based on laws from more than one jurisdiction. We would add that investigators and lawyers, including judges, are quite adaptable in working across different jurisdictions. We would also point out that many prosecutions involve indictments containing both Commonwealth and state or territory offences. These are hardly practical problems for a national CCRC. Professor Hamer suggests a very simple approach to the need for constitutional power to be bestowed so as to permit an effective national CCRC to be created. He suggests that the states could refer powers pursuant to Section 51 XXXVII of the Constitution to legislate on the subject matter of a CCRC. Presumably the territory's power would do a power of work in respect of the NT and ACT. It sounds very simple. Defining a CCRC for that purpose would need to be carried out with necessary precision. I tend to think that analysing and identifying each power required for a CCRC and referring each of those powers might require less adjustment after the fact if a CCRC's role evolves over time based on experience. Professor Hamer thinks that it would be asking too much of the states to refer a CCRC power. I tend to think that persuading the states to refer the power once the Commonwealth is persuaded to establish a national CCRC will be comparatively easy. That's very much a comparative, very much a comparison, because the first one's so hard that the second one is comparatively easier. In any event, those are the sorts of things that we'll be thinking about and talking about this afternoon. Professor Hamer suggests that a better approach may be a better and more practical approach may be for the Commonwealth to establish the national CCRC focused on the things that come properly within a national CCRC, and then have the states refer powers to that body dealing with the state jurisdictions. He does point out as well that since the CCRC is an executive and not a judicial body, the constitutional problems that arose in the cross-vesting of courts legislation are unlikely to arise. Professor Hamer points out that state legislation already bestows power on federal executive institutions in areas such as financial regulation. He refers to ASIC, and air safety. He refers to powers bestowed on CASA. It seems, therefore, from what I have said, that there are constitutional means by which a national CCRC can be bestowed with the necessary powers to investigate and identify wrongful convictions across all Australian jurisdictions. The fine detail of these means should be developed at the same time as the legislation establishing a national CCRC is itself developed. Not only do I not have anything more to say, I'm happy to finish there in any event. Thank you.